Sharp Quickie. In 1978, Alan Bakke, a 35-year-old Vietnam War veteran, was rejected from medical school at the University of California, Davis twice, solely because of his race. He was white. Every year, the school accepted 100 people, and 16 of those accepted were from minority groups. He was rejected despite the fact that his grades were better than the 16 people who got in on minority seats. The California Supreme Court struck down the quota as racist and ordered Bakke admitted. The university fought it all the way to the Supreme Court. They ruled 5-4 that Bakke should be admitted. However, they also said race could be taken into account to promote diversity on campuses. This is another one of those crazy ones where there are 6 different opinions. Lewis Powell wrote that it was one thing to have the percentage of black students as a goal, but as a qualification, that was a road too far. Racial protections apply to all races, not just minority races. Quote, "The guarantees of the 14th Amendment extend to all persons. The guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. The individual," he said, "is entitled to their rights, not classes." And the program completely disregarded individual rights as protected by the 14th Amendment. William J. Brennan, joined in various parts by 4 other judges, yes, it's confusing, wrote, "Government may take race into account when it acts not to demean or insult any racial group, but to remedy disadvantages cast on minorities by past racial prejudice." In other words, don't lift someone up by knocking someone else down. John Stevens pointed out that the court wasn't saying that race could never be a factor, but it cannot be the basis for excluding anyone of any race. Marshall basically did a lot of table pounding in his dissent. After spending 8 pages preaching how bad slavery was and another 6 on Jim Crow, he wrote, "I fear that we have come full circle, because not getting blacks preferential treatment and admission to medical school is exactly the same as enslaving them." Gotcha. Justice Harry Blackmun wrote, "In order to get beyond racism, we must first take account of race. There is no other way. And in order to treat some persons equally, we must treat them differently. So we have to make up, down, left, right, and go forward by moving backward." The sad part is he probably thought he was being clever. All of the dissenters claimed that they yearned for the day when such quotas were unnecessary, but would have left no room for future courts to even determine when that was. And since this case, despite affirming that race could be taken into account, the percentage of black freshmen in the U.S. has not changed. Blacks make up 6% of freshmen, but are 15% of college-age Americans. That says that whatever the problem is happens before the college application is filled out. A quota would have been papering over the problem, not solving it. In 2023, these wayward opinions were made clearer by a joint decision of Students for Fair Admissions v. Harvard and Students for Fair Admissions v. North Carolina, which gave the pretty obvious point that not being racist meant not making race a compelling interest. It's really one of those by definition things. John Roberts, reiterating Powell's opinion here, wrote, "Eliminating racial discrimination means eliminating all of it. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color." Maybe now the 14th Amendment can finally mean what it says. No, Samsung. I'm never buying another Samsung tablet, I swear. No, god damn it, will you stop that? Why on earth would you think that's what I want to do Now, where even am I? I see what I have to put up with here.